like an awful lot of time to talk.
15's good.
Yeah. Sounds a little more appropriate. I normally don't like giving much of my background, but since you've asked me to do that, I am a lawyer in town. I've practiced law actually for 37 years, so I've been doing it for a while. And my background is kind of unique in that I have a law degree from Duke University, but I also have a master's degree in city planning from UNC Chapel Hill. And about 10 years ago, actually 2 of my former classmates of mine asked if I would start teaching down at Georgia Tech, and they gave me a very fancy title called Professor of Practice of City Planning. So I'm the guy down at Georgia Tech who teaches all of the planners about zoning and land use and management and control of growth issues. And I have tried very hard over the years. In my early days, I did a lot of zoning cases. Almost all of them were on the neighborhood side. And you probably, well, actually some of you may well remember this, but 37 years ago, neighborhoods were not winning many zoning cases. And I decided to pursue something that would be where I would occasionally win. I probably should have stayed in that field, but moved on to do general real estate, which is what I have done over that last 10 years. But a couple of years ago, I wrote a treatise on zoning and land use law, which is, I think, how Robert probably found me. And I do want to say, starting off, that I do not live in Dunwoody, although I live very close at Spalding Drive and Brandon Hall Drive, if y'all know where that is. Until the cities actually started forming, we would have described ourselves as Dunwoodyites. And when I told my wife that I was coming to speak with y'all tonight, she said, "Is there anything I could do to encourage you to have a restaurant in Dunwoody Village where they shut down the, what was the name of that greasy spoon?"
The old Hickory House. Shame on you. Greasy spoon.
I am advocating for, well, when you're raised on Southern food, that old Hickory House to her was something, was the best, and she felt that maybe Robert could personally influence, use his influence.
We're going to turn it into a bank. So when you go home, tell her that it's going to become a bank branch.
That was very distressing to my wife. In any event, I also want to say we're actually dealing with some issues here where there's not a lot of reported law. In the zoning and land use area, you probably have about 25 cases, and what lawyers do is they extrapolate from the local cases and the national cases to try to predict outcomes. So the things I am telling you, I am sure that if someone was told be an advocate for a particular position, I am sure a lawyer could come up with a different position. But what Robert asked was that I not be an advocate and not take a particular viewpoint other than to take a look at the question of, is it a conflict of interest for a person to serve on a governmental board in the city of Dunwoody and also participate in the Dunwoody Homeowners Association? And that really led me to looking at a number of things. And the first question I always ask the client is, one, what is your goal? And Robert said, I just am looking to understand the context in which we're operating because I have some concerns that this policy is overreaching. And he said, other than that, I just want you to look at it and give your honest evaluation of what you think of this policy, which is what I did. I then asked Robert what was the city's goal in trying to adopt this policy if you kind of separate the politics from just the substance of it and just ask what on its face were they trying to achieve? What Robert at least explained is that the city is concerned that it is getting sued a lot, and the concern was that this potential conflict of interest could be something that could lead to more litigation against the city and lead to litigation where the city loses. And one of the things I can say categorically is cities get sued. And frankly, in the zoning and land use area, cities get sued quite a lot. And one of the reasons, obviously, that cities get sued is that there's this dynamic tension between property values and people having the right to use their property as they wish versus legitimate governmental regulation. And at some point, regulation can constitute a taking. And if you can prove that a taking has occurred and you can get your property rezoned, you can, as we all know, make a lot of money. So there is always going to be a financial incentive for property owners, and typically who are developers, to bring lawsuits against the city of Dunwoody. And having now looked at the law in this area, I very strongly believe that there is, that if this policy is adopted or not adopted, it's not going to affect in any way, in my opinion, the amount of litigation that gets brought against the city of Dunwoody. I think you are going to continue to get sued, and unfortunately, I think that's just part of the game of being a city. There are many benefits to being a city, but there are also some downsides, and one of the downsides is you get entangled in litigation, which can be costly. I started my research by looking at the question of, is there any state laws dealing with conflicts of interest in the zoning arena? And there is a state statute. It does define a conflict of interest, but it does not define it in any way in relation to a person serving on the board of directors or being a member of a neighborhood association, while at the same time serving as a governmental official in some way. The state law only deals with situations where you have, as a governmental official, a property interest or a financial interest in matters which are being brought before you. So the state has legislated on the issue of conflicts of interest in the zoning area, and it has specifically not said that serving on the board of a neighborhood association is a conflict of interest. As a matter of fact, the statute is absolutely silent on that. And one of the things I would certainly tell you is our laws are such that you can do everything that is not prohibited. Our legislature obviously took a close look at this issue and decided that regulation only needed to apply with regards to conflicts of interest when the governmental official, again, has a property interest or a financial interest. So that was the first thing that I took a look at, and fundamentally there is not any state regulation which would indicate that such a conflict of interest would exist. And part of what I then spent a lot of time thinking about is, well, what is it? Why does the city of Dunwoody, or some people in the city of Dunwoody, believe that this is an inherent conflict? And to some degree, you really need to look and understand kind of zoning in a broader context, because zoning is looked at as a legislative power. And it's a delegation, actually, of that legislative power from the state to a city government. And when the city government, i.e. the city council and the planning commissioners, are considering rezoning cases, they are acting in what is thought of as a quasi-legislative role. And when you start to think about is it logical or fair or constitutional to impose restrictions on legislators? I would be the first to say that as a practical matter, someone acting in a legislative capacity certainly should be able to evaluate all of the universe of facts that are out there in coming to a conclusion or an opinion as to what to do on a particular case. And if you look at it, legislators, planning commissioners, and city council folks are regularly lobbied by lawyers and developers and neighborhood groups. They certainly have, when you start to kind of analogize to serving in the Georgia legislature, does a Georgia legislature have any limitation on coming from a particular point of view or cutting off all ties to outside organizations? And the answer is absolutely not. If you're a legislator and you're a member of the National Rifle Association, you may be advocating for gun control laws at the Georgia legislature. That's not a conflict. It is simply in your role as a legislator, you are free to come to the table with your views, opinions, and biases. And frankly, you are free to learn about the issues at hand however you would like to learn from them. And you can certainly use your position to advocate for specific legislation. So if I'm a realtor and I'm a member of the Georgia legislature, and there are many of those, or some of those folks regularly advocate for laws which are in the best interests of the real estate industry. Analogizing now to the legislators in the city of Dunwoody, I have found nothing that would indicate that your activities need to be constrained or else it creates a conflict of interest. Now, there's a bit of a distinction here. When you serve on city council, when you serve as a planning commissioner, you agree to follow certain processes. You agree to be fair in terms of giving people an opportunity to be heard. That's what's called in America due process. But due process does not require you to come to the table leaving all of your views and opinions at the door. You are free to come to the table with whatever background, education, prior experience, friendships, views, and political views of the world in formulating a decision. And some of that, in my opinion, can be done at the meeting. Some of it can be done prior to the meeting. And I see when you are acting in a legislative capacity, absolutely no limitation whatsoever on who you can speak with, what meeting you can attend, and whether you, if you participate at a higher level, whether you are then voting at the neighborhood association as well as a city council person. And there is not a reported case in Georgia to the contrary to what I had just said. As a matter of fact, there are cases, if you look at this memo in greater detail, which support what I have just told to you. Now, separate and apart from the conflicts issue, there is also some constitutional issues, which a policy which says you may not participate in certain groups and you may not speak with those groups or participate. I am a great believer in our United States Constitution. As an officer of the court, as someone who teaches about the Constitution and its impact in the land use area, we live in a world where we have a right to freely associate with whoever we would like to associate with. We live in a world where we have a right of free speech. And when government says to anyone we are going to limit who you can associate with, and we are going to limit who you may speak with, and you're not allowed, if you're going to serve on this particular board, you must give up all other allegiances. I think that starts to trample on fundamental constitutional rights. And when you start to trample on constitutional rights, particularly rights protected under the First and 14th Amendment, our courts tend not to look and ask the question, is there some rational policy to support this, or some rational basis to support this policy? The courts don't even ask, is there some substantial justification? When you were trampling on constitutional rights, what our courts say is government must have a compelling reason to trample on constitutional rights. And I just cannot think of a compelling reason why the city of Dunwoody would adopt a policy saying we are not going to allow you to associate with particular neighborhood organizations or with any neighborhood organizations. And if you start to think about and drill down on, well, what neighborhood associations are we talking about? Could be the Dunwoody Homeowners Association. It could be the Davis Academy. It could be a local church. And do we really want to get into a world where the government is saying which groups we can participate in or not? And I happen to think that if challenged, a court would strike down the policy as overbroad and unconstitutional, because if you have a compelling reason, well, first of all, the compelling reason, it cannot, in my opinion, be we might get sued. Because there is not a Georgia case reported at an appellate level where a court has ever held serving on a board and in the neighborhood association is a conflict of interest. So it is a policy designed to address an issue where there's been no court case ever saying that this is something that that's going to get you sued. And having practiced law for 37 years and having been at least on the periphery of the zoning and land use area, I regularly see lawyers take very aggressive positions. And could I see a lawyer say, well, gosh, this is a conflict of interest and we're going to sue you because of this conflict of interest? Sure, anybody can sue you for anything. The question is, at the end of the day, does that claim have merit? And there is no lawful basis I have found to support such a claim. Now, having looked at a lot of different issues in this area, there is one issue, or there are a couple of issues I kind of want to tell you about. The first is the legislative power can only be delegated to the governing body. That's the city council. If a city council were to then delegate the power that the state gave to them, it could create an issue. And by that I mean, you're on the city council? If Terry were to say, I am a puppet for the Dunwoody Homeowners Association, and whatever it is they tell me to do, I'm going to do, and all of the other city council people are going to do the same thing, what that would mean is you are not exercising your legislative powers, you're delegating them to somebody else. Everyone with me on that? And one of the things I suggested in the memo is maybe out of an abundance of, well, one, you shouldn't do that, Terry.
I don't, for the record.
And I'm sure you do not. And two, maybe the Dunwoody Homeowners Association should adopt a policy that says something like, oh, by the way, whatever we vote on, you are not necessarily bound to in any way, and you're free to make independent legislative decisions, which to me eliminates kind of the complaint or this one area called unconstitutional delegation of legislative powers. Now, there is this other kind of tangential issue out there where the law is very unsettled, and it relates to, there's two other things I want to talk about, I'm going to finish up. It relates to this issue of what happens when you're not acting in a legislative capacity, which is how our courts look at the Planning Commission and the City Council, but are acting instead in what the courts view as kind of a quasi-judicial capacity. And a quasi-judicial capacity is when you might serve on a board of zoning appeals. And actually what our courts say is in that instance you're not a legislature, you're kind of acting in that role as a judge. Because what you're really doing is you're interpreting the city's zoning ordinance, and that is in the nature of a kind of, that's more quasi-judicial, not legislative. And the distinction has been made in the law, frankly, all over the United States between legislative functions and judicial functions. And sometimes I see members of a board of zoning appeals act differently than city council folks. I think city council folks have basically the discretion to do whatever they doggone want to do in deciding how to vote in a particular case, so long as they afford all applicants due process. With regards to serving on a board of zoning appeals, that might be where if I were, and I was once actually on a board of zoning appeals, and it was my practice when I served on the City of Decatur's Board of Zoning Appeals 25 years ago, I would not talk to folks in advance. And if a lawyer called me on the phone, I would say, I only will speak to you if the other lawyer is present. Because actually that's what judges do day in and day out. They are a little more judicial and removed. And in many jurisdictions, you do see people on boards of zoning appeals acting a little differently and a little more removed than people serving on city council or serving on a planning commission where I think, frankly, anything goes. Now, does that mean that that person could not attend a meeting at the Dunwoody Homeowners Association? No. I have said to Robert, and in my memo, out of an abundance of caution, if I were a member, if I were on your board of zoning appeals and a member of this association, I would probably not vote on an issue coming before the board of zoning appeals. I wouldn't previously vote on it here at the DHA. I might recuse myself from taking action. The other issue we ended up looking at was this issue of open meetings. And interestingly, the law in this area was amended in 2012, and it was amended in a way that when I went back and I read it, it surprised me how arguably limiting it is. And let me just take a second and read you the relevant section of the open meetings law. Here's what it says. This is what constitutes a meeting. And it says a meeting is a gathering of a quorum of the members of a governing body, of an agency. So that could be a majority of the planning commission, a majority of the city council. Interestingly, this would not apply to members of a board of zoning appeals, but it does apply to planning commissions and city council. But it's a quorum of the members at which any official business policy or public matter of the agency is formulated, presented, discussed, or voted upon, or the gathering of a quorum of any committee created by the governing body at which any official business policy or public matter of the committee is formulated, presented, discussed, or voted upon. And what does that mean in plain English? Well, if a majority of the city council were here and a case that was going to city council was being discussed, that case is official business of the city council if it is already registered as a case. And if you had a majority of the city council folks here at that meeting, you could argue, make a pretty good argument, that that might constitute an open meetings law violation because you now have more than a majority here. Even though they may not be talking to one another and sitting in separate parts of the audience. I don't know, though, that that's such an obstacle that when you think about, well, how do we kind of come up with some rational policies? Some of my policies would be, well, could you get a majority of the city council together for the annual meeting at the Dunwoody Homeowners Association? Absolutely. Could you get a majority of the city council together to talk about land use issues in Dunwoody? Absolutely. But if you're hearing case number Z12, that is when I would say, if you have a majority of the members of council present, one of them should leave. It's just that simple. I think I have about wrapped up my remarks. I don't think, as I said, the policy being proposed by the city is either rational in terms of the problem it's at least purported to try to address. I think if challenged, it would be struck down as unconstitutional. But I do think there are some safeguards you could adopt, such as adopting a policy which says whatever we do, we are not binding any member. I think if there's a case to be heard before you and there's a majority of the city council or planning commission, it's easy enough before you get the meeting started to make sure there is not a majority. That is the type of thing that, again, would avoid an open meetings type of claim. And with that, let me stop, because I'm sure there are probably some questions that people have. Why don't I take some questions from the group that y'all might have?
Right. First, you're live on Facebook for the people who couldn't be here tonight.
Okay.
Second, when our mayor called one of our DHA members and made her choose between membership in the DHA and her place on the Zoning Board of Appeals, are you saying that her civil rights were violated?
Let me just...
Wait.
Okay.
Let him answer.
Okay.
Well, I don't know that I would say her civil rights were violated as much as I think if you, well, first of all, for a law to be adopted, it has to be adopted in an open meeting. And laws have to be in writing. You know, fundamental to our Constitution is if you have a law that I'm imposing on you, it can't be something secretive that you can't read about and put in Dick Williams' newspaper, which I read, and I almost took a copy to Italy with just made in front of the Vatican, Dick. But whether it constitutes a violation of her civil rights, I think the mayor enforced a policy which was unlawfully adopted, is my opinion. And my opinion is he is enforcing a policy that, if challenged, would be struck down. But, you know, I am sympathetic to the city in the sense that you're a new city, you're getting used to how the world works, and frankly, when you're a new city, you're getting sued a lot, and it's not in the budget, and you may have to raise taxes as a result. If I were the mayor, I'd be thinking long and hard as well about what can we do to try to mitigate this. I just happen to think that the solution they have come up with is not constitutional, it's not going to achieve the desired goal.
Bob?
3 quick questions, I promise. First of all, just for the record, the lawsuits we have gone through so far in the city have not been a result of conflict of interest between this board or anybody else. Okay, they were actions based on the council's votes, independent of the DHA. And I have never known an elected official to take the DHA's word as marching orders in a public meeting anyway. So, 3 quick questions. Maybe 2. The DHA meetings are always open to both sides.
Sure.
We hear both sides. Developers come in, they pitch, the mayor and city council, whoever's here is hearing that. The developer also gets a chance to have questions asked of the general public, and these meetings are always open. Does that eliminate the idea of any type of prejudice or conflict that these meetings may result in, since both sides are getting a chance, or being given a chance in open dialogue to ask questions?
Well, I think, you know, this law is a lot like a hammer rather than a scalpel. So, you know, could you make different arguments depending on whether you're in the audience here or whether you're on the board? You probably can. But, you know, again, as a professor of city planning, what I would categorically say is the process is one. Most zoning actions ultimately result in some kind of compromise. And what any planning professor would say is the more people get together and talk and have opportunities to talk and discuss the issues, the greater the likelihood there will be a compromise.
And nobody gets sued.
And nobody gets sued. And really, you want to encourage developers and neighborhoods to meet, and having a Dunwoody Homeowners Association is not a unique situation. There are neighborhood associations all over the metro area, and they serve a very positive function of helping to bring the parties together and helping to reach compromises. And the fact that a decision maker ultimately may be participating in the neighborhood group, you know, let's say you banned a person and a judge for some crazy reason would say, well, this is perfectly lawful. Well, the member of city council could still come and read your minutes. He could go online, he could call everyone who was at the meeting and say, what happened? He could call Dick Williams and say, Dick, you were there, what happened? So the thought that there's some magical thing that happens here at the meeting that must be stopped, to me is very illogical.
And I'll ask, my last 2 questions is one. It is my understanding from the multitude of attorneys I know in zoning, Doug Dillard and Zickert and all those guys.
And I know them all as well.
I read your book. Is there any case law in a zoning decision or any case law in a Board of Appeals decision, okay, which strike out the possibility of somebody sitting on these boards? I served in the Board of Appeals for a long time in DeKalb County.
No, categorically,
No case law.
no case
So
law.
when the city attorney writes a memo and cites all of these reasons why this is a potential, and cites no case law,
Right.
in his opinion, in your opinion, Is that a proper opinion for a city attorney to write to its board?
Well,
Citing no law.
Yeah, you're asking me to address a question I'm gonna dodge.
Yeah.
You can dodge it. I had to ask you.
I'm not having seen the opinion or read it, it's really not for me to judge another attorney's work. Having taken the time to write a treatise on the law in this area, you know, we looked at literally every zoning case decided in the state of Georgia. Now, I will say the only recorded cases are appellate cases. So there could be maybe some allegation in some trial court that's not a...
But only appellate cases make the law.
Correct. Yeah, only the appellate cases have the effect of judicial precedent.
Thank you very much.
Yeah, and there is no case.
In either case.
In either case. Now, I said in my memo, I'm fairly conservative as a person and as a lawyer, and there may be some reasons why when you're serving in that quasi-judicial role, you want to act differently than when you are in a legislative role. But when you're in a legislative role, as I said, it's no holds barred. I think you come to the table with your views and opinions. You can belong to whatever groups you want. You can prejudge any doggone situation you want. You can have your biases and prejudices, so long as you also give people a fair hearing, which is what planning commissions and city councils do day in and day out.
Stacy?
I just had a quick question. I do actually serve on the zoning board of appeals, so, and I was never actually sent the memo. They sent it to the wrong email address, but in it cites that it gave us the memo with the policy and then said that we can't talk about it because of attorney-client privilege. So my question is, who was my attorney? And why was I a client?
I mean, frankly,
And
it
why
sounds
didn't I
a lot
talk?
like a Star Chamber kind of proceeding. It is not how we do business in America. You know, we are a free country where people have a right to speak and they have a right to associate. And government can't say, I'm going to make you make a private choice and don't talk about it with anyone. To me, that's a ridiculous position to take.
Okay. Then, in the same memo, then we were threatened with a violation of ethics if we did, in fact, talk about the memo.
Again, to me, it's Star Chamber stuff.
Okay.
This is the United States of America. Government is conducted in the open. We don't put private constraints or restrictions on who you can associate with, who you can speak to, and are you obligated not to engage in conflicts of interest? Yes. Are you obligated to comply with lots of laws? Yes. But not the Star Chamber stuff. That's just crazy.
Thank you.
Bill, last question for you.
I don't think Lindy's smart enough to be on the Star Chamber.
Was that your question?
That's it.
Okay. All right, well then I'll let Bill Grossman have the last question.
I sit on the planning commission. I'm one of the 5 people that the mayor did call that day.
Oh, yeah, another one.
I'm also one of the 26, there were 26 people on the list who were sent the memo. Like Stacy, they got my email address wrong too, even though Lenny had sent me emails before. Would it be illogical for me to use, and I have requested a public comment to be sent an actual copy of the memo. I've asked in person, I've asked in writing, and I've yet to receive an actual copy. Until Mr. Luston posted it on the internet, I had never seen it. But my name is on the list. Would it be inappropriate for me to use Freedom of Information request to get a copy?
You could, and there probably would not get it, and then the question is, would you want to litigate over that issue? You know, the one thing I would encourage, I spent many years of my life representing condominium and homeowner associations. because that's another thing I have done in a previous life. And actually what's going on reminds me a lot of what I see in, I used to represent Windward, which graduated to the, Bob Fulton was actually the first president that I worked with, God rest his soul, and he ended up as chair of the Fulton County Commission. But this reminds me an awful lot of the kind of dispute you would see in a homeowners association. And I would encourage everyone, I think the city took a misstep. I would be amazed if the city tries to double down and continue with the policy. And I would encourage everyone to try to look in a more forward and productive sense, because I do think there are some legitimate questions about how everyone acts, and I think that this has probably led to some good discussion, and hopefully a policy can be adopted that might be more productive and certainly constitutional than the one which was adopted. I do know, though, how angry you must be when you get an email saying we're not going to allow you to associate.
Well, I never actually got the email, and that's the point.
Yeah, but again, that, we live in a country with a constitution, and we should all. I happen to think that man who spoke at the convention who upheld that little pocket. I have a little pocket constitution, and I always have. And it's a great document. It gives us great rights. It gives us protections against government abuse. And I think the government went too far. I think hopefully the government will realize that and back off. If not, I suspect things will get worse rather than better, and I don't think that's productive for anyone.
Seth, thank you very much. We really appreciate your help.